Hello and welcome. My name is Callum Birnie. I am a fourth year law student at QUT, and in this presentation I will be assessing and evaluating the Australian consumer law and its particular relevance to startup businesses. Specifically, I will be outlining the importance of misleading conduct under Section 18 and the consumer guarantees provisions. The Australian Consumer Law, or more commonly referred to as the ACL, is contained within the larger Competitions and Consumer Act 2010. Although it is contained within this act, it is often thought of as an act in itself. The ACL is an amalgamation of uniform national laws that focuses upon ensuring fair and safe consumer transactions. This is achieved through the imposition of several protections, guarantees, and expectations that a person or corporation owes to consumers in the course of their commercial conduct. These rules can best be thought of as impliedly forming part or being attached at the end of every applicable business or commercial contract. So why is a knowledge of the operation of the ACL relevant for startups, especially those within the position of corporate management? Well, put simply, due to the inclusion of the ACL within any applicable contract and the access to justice issues that startups notably face within their pre-seed phase, an understanding of the ACL's operation is paramount to ensuring business efficacy. Due to the likely inability to acquire legal counsel, startups often use standard form contracts. All of these are great resources. These are resources that are not tailored to startup ideas. That being, they use standard form templates for often innovative and boundary pushing ideas. As noted in articles run by Forbes and All Business, investors become apprehensive to invest when directors do not have a comprehension of business law, and this is due to the risk factors that I just listed. Therefore, an understanding of the ACL will not only help startups avoid pitfalls within contractual dealings, especially with clients, but it will also present a far more attractive business opportunity for venture capitalists. Further, it is critical to understand that the ACL is extremely resilient to contractual exclusion. Under Section 64 of the Act, contract clauses purporting to restrict, modify, or exclude consumer guarantees are rendered void to the extent of their non-compliance. Put simply, this means that if any contract clause in any way does not follow the consumer guarantees within the ACL, it is cut out of the contract. Australian courts have also noted that this is applicable to misleading and deceptive conduct, so that can also not be excluded. If you are interested, please have a look on the slide for the case authority. This will leave the contract on foot, meaning that it's still continuing forward. However, the non-compliant clause will be severed and cut out of the contract. As consumer guarantees and misleading, deceptive conduct cannot be contractually excluded, they will form the focus of this presentation moving forward. So now that we have an understanding of the ACL, what commercial dealings or contracts are applicable? To evaluate these threshold questions, I have placed the relevant provisions on the screen. So looking at this, we're going to think like a lawyer and dissect the threshold questions from these provisions. Once we do that, we get three terms, that being person, in trade or commerce, and finally consumer. So let's have a look at person first. So person means both a natural flesh and blood person like myself and yourself, but also artificial persons such as corporations or companies post-incorporation. Secondly, we have in trade or commerce, which, to put it simply, essentially means that you are undertaking the transaction for a business or commercial reason. And finally, consumer. When we talk about consumer, it is in reference to someone who enters into a contract which is under $40,000, and the goods or services provided underneath that contract are a kind that's ordinarily acquired for personal or household use or consumption. That being anything that's acquired without the need for an external business. So for instance, going down to Bunnings and getting a 2x4 to do home renovation is completely fine, that would be within the consumer. However, if you buy a ton of wood and you use that for your renovation business, that would not fall underneath the definition of consumer. So now we will examine firstly misleading conduct before moving on to the consumer guarantees. Section 18, misleading conduct, deals in general with product assertions and representations. The provision itself states that a person must not engage in misleading or deceptive conduct or conduct that is likely to mislead or deceive. To consider this question, we're going to break it down into two portions, the first of which being what constitutes misleading or deceptive, and the second of which is what conduct can we look at. So firstly, considering what is misleading or deceiving. So case law outlines that conduct is misleading or deceiving where the conduct viewed in the context of all surrounding circumstances has a tendency to lead a reasonable member of the target audience into error. So if we look at our previous explanation of section 18 and also the wording of tendency within our case law explanation, we might note that there is no requirement to strictly mislead or deceive. The section 18 is suffice where it is only likely to or has the tendency to. The reasonableness of the target audience is evaluated subject to that group's assumed sophistication and knowledge around their target subject. So, for example, if we have a look at the case of Google Incorporated against the ACCC, which was a 2013 case, it noted there that reasonable users of Google would have understood that sponsored links were created by advertisers and that any representations attached to those links were made by the advertisers and not Google. So that's one example of the knowledge which a target group, and in that case it was general internet and Google users, would have. A second consideration is conduct. So what is generally accepted to be misleading? The ACL defines conduct broadly as doing or refusing to do any act. Usually this materializes as representations made throughout the course of communications between one party and another, whether that be orally, online or written, or it could be contained within an advertisement that's posted to the world as a whole. So as we noted before, it also includes refusing to do actions, which means that silence, whether by itself or including other actions, may be misleading. Generally, to put it simply, silence is misleading on its own where someone has a subjective intention to mislead, and where silence is combined with other actions, it is only misleading when, as viewed as a whole, the silence and those other actions purport more than just a mere silence. Another recognized category of misleading conduct is opinions. Now, opinions are likely to be misleading where the person making that representation has personal knowledge on that matter. So, for example, with an eBay seller, they may elect to sell their laptop to a person, but they do so knowing that the laptop has a faulty battery. Now, when the person asks, "Hey mate, do you think that this would run perfectly? Is there any issues with it?" and the seller responds, "I think there's no problems at all," that is opinion that will be misleading. Furthermore, statements of future events or predictions are likely to be misleading where the person making them knows it to be false or does so with a reckless disregard for the truth. So if we go back to our eBay analogy, the person who's selling the laptop with the faulty battery sells it to someone underneath the representation of, "I think it can last 5 years. However, that faulty battery can only last 2 years, and that would be misleading." So opposing these generally accepted categories of misleading conduct are categories of conduct which is generally considered not to be misleading or deceptive. This includes puffery statements and supplying the information of another person. So firstly, looking at puffery statements. Puffery statements are statements which are clear, exaggerated assertions made for a product that a reasonable member of the target audience would not be expected to take seriously. So essentially hyperbolic statements. Whereas passing on the information to another, as long as the person providing that information says to what degree they find it to be true, it will not be misleading. However, particular care should be taken to audit this information, as once it is found out that information is false, it is the duty of the person who passes that information on to delete it from their website, advertisement, or assertion. Now we will move on to assess consumer guarantees. These guarantees are separated into two major categories, that being guarantees as to goods and guarantees as to services. As two different sets of guarantees apply to each category, it is paramount to recognise what your product is classified as. Under the ACL, goods are defined broadly. They use an inclusive list rather than an exhaustive list, which doesn't limit the goods to the particular categories that are listed on the slides. Similarly, services use an inclusive list as well, and if you have a look on the slides, the definition there, which is extracted from the ACL, just provides for the generally accepted meaning of services, and that's deriving some right or some benefit from someone else's use of that property. However, do note that the ACL does not provide that financial, transport or storage, insurance, architectural and engineering services applicable. In the situation where a product both encompasses goods and services, then that product viewed as a whole would be considered goods. For an example of this, we'll have a look at the 2016 case of the ACCC against the Valve Corporation, number 3. In this case, the defendant had a product called Steam, which allowed users to access third-party software, and that was in the form of video games, and this platform also supported digital asset downloads. Even though Valve Corporation was providing a service to access these third-party downloads, because it was providing the software of Steam, it was considered as a whole to be a good. So we'll firstly assess consumer guarantees relating to goods. These are contained within sections 51 to 59 of the ACL. These guarantees are the undisturbed title to goods, the undisturbed possession of goods, no disclosed securities, goods of an acceptable quality, goods fit for purpose, goods correspond with their given description, goods comply with the sample product if that's provided, repairs and spare parts for the product is available, and they comply with the manufacturer's express warranty. Now, if we move on to consumer guarantees relating to service, these are contained in sections 60 to 62 of the ACL. So these guarantees are that the services will be rendered with due care and skill, the services will be fit for a particular purpose that's made known to the supplier, and subsection 2 of 61 goes to expand upon subsection 1 by essentially saying that if there is any prior negotiations and a specific result was made known within those negotiations, then that also is a guarantee. And finally, that the services will be completed within a reasonable time. So just to do a quick overview of everything we've covered today, we have gone through the ACL, what it is, why it's important, particularly for startups. We've had a look at misleading and deceptive conduct. We then looked into consumer guarantees. So I hope that this was an informative and positive process, and look forward to seeing some of you at the Q&A process. Thank you.